Welcome.
Thank you. And to clarify, my testimony is about the constitutional amendment and the following bill. Is that okay if I do both at the same time?
So it'll be SJR 124 and SB 940, just for committee members. Okay, go ahead. Thanks.
Chairman Kapinga, and members of the committee, thank you for the opportunity to submit testimony on Senate Joint Resolution 124 and Senate Bill 940. My name is Erin Gamble, and I'm Associate Counsel at the Wisconsin Institute for Law and Liberty. Wisconsin's Constitution is explicit. The legislature writes laws, the executive branch enforces them, and the judiciary interprets them. Yet over many decades, the legislature has transferred broad policymaking authority to administrative agencies. As a result, unelected bureaucrats impose steep costs on Wisconsin families and small businesses with little accountability or oversight. While the legislature delegated its powers to the executive branch over the years, there was always one saving grace. That is, the legislature maintained robust oversight over rulemaking. If an agency promulgated a bad rule, a constituent could contact their elected representative, and the legislature could suspend or object to the rule. This process saved Wisconsinites from burdensome regulations. However, Mark Line 2, a case handed down last summer, changes the dynamic between the legislature and the executive branch. By limiting the legislature's ability to review or block rules without going through full bicameralism and presentment, the court has made it significantly more difficult for elected lawmakers to oversee agency actions. Therefore, the court's holding has caused a separation of powers issue. Now the executive branch can write and enforce the laws of Wisconsin. If no changes are made, Wisconsin will increasingly be governed not by the laws passed by the people's representatives, but by regulations written by bureaucrats. We currently have an imbalance of power weighing heavily in favor of the executive. Thankfully, there are two legislative fixes in front of this committee today that would go a long way to reestablish a balanced system. First, Senate Joint Resolution 124 would amend the Wisconsin Constitution. The proposed amendment would allow the legislature to suspend any administrative rule in whole or in part through passage of a joint resolution by a majority of both legislative houses. The suspension of an agency rule would last indefinitely or for a period of time specified in the resolution. With this constitutional amendment in place, it would permanently establish that the legislature has final say over rulemaking in Wisconsin. After all, rulemaking is a legislative function. Administrative agencies are nothing more than creations of statute. They only exist because the people of Wisconsin willed them to exist through the legislature. Therefore, when a majority of both houses of the legislature agree that an administrative rule falls outside the bounds of power that the legislature granted to the agency, the legislature should simply be able to pass a resolution to suspend the rule. This isn't controversial or political. Rather, it makes agencies responsible and accountable to the will of the people. Wisconsin would not be the first state to ratify such an amendment. In fact, at least 6 states have amendments in their constitutions that allow state legislatures to suspend or nullify rules. Some state constitutions allow a single legislative agency to review and suspend rules, which was similar to how JCRAR operated pre-Mark Line 2. Other states, like Iowa and New Jersey, require more input from the state legislature as a whole by allowing rules to be suspended with majority support from both houses. Senate Joint Resolution 124 is a common sense solution which would reestablish legislative oversight over rulemaking, require bicameral action to suspend a rule, and ultimately make agencies accountable to Wisconsinites through their representatives. Next, Senate Bill 940 would ensure that agencies promulgate rules only when the legislature has explicitly and specifically granted such authority in the statutes. Currently, Wisconsin Statute 227.11(2) sub a grants broad authority to agencies to promulgate rules interpreting any statute that they, quote, consider necessary to effectuate the purpose of the statute. With this statutory language, executive agencies are essentially free to legislate on vast topics despite having no legislative authority, direction, or oversight. The result is that unelected bureaucrats now issue rules that carry the force of law, shape major areas of public policy, and inflict real costs on Wisconsinites. As previously highlighted, rulemaking is a legislative function. Agencies only have those limited powers explicitly given to them by the people of Wisconsin. Therefore, when agencies engage in rulemaking, they should strictly abide by the powers explicitly given to them. Senate Bill 940 would repeal that deferential language in WSStat 227.11(2) sub a The current ill-advised language would then be replaced with statutory language that directs agencies to only promulgate rules that are explicitly and specifically authorized by the legislature. This is an easy legislative fix that would have a great impact. It would rebalance power and put policymaking back in the hands of the legislature. In sum, the Wisconsin legislature has delegated significant legislative powers to the executive branch, but the proposals in front of the committee today offer great solutions to bring legislative power back to where it belongs, in the legislature. I'm thankful for your time today, and I'm happy to take any questions.
So if these pass, let's just take the SJR passes. 2 consecutive sessions of the legislature, people voted in, and Governor Kapinga issues a decree or an executive order that says you may not wear masks anywhere in the state at any point in time. And let's say that Senator Drake is running the Senate at the time, and we played this scenario before.
Right.
I was wondering.
We're not ready.
It's like in Washington somewhere. So that in that situation, the legislature would have the ability to step in and say, hey, we do not think that that is appropriate action. We feel there are warranted medical reasons to have masks on. Therefore, we're going to override that governor because he's not in line with the voice of the people. Is that essentially what would happen?
Correct.
Got it. Okay, I just wanted to make sure I understood that. Okay. Good question.